Mr. Baskin, before we get started, I was wondering, have you ever represented a puppet who lost his inheritance because of an error in a will?
No puppets, but I'm looking forward to my first case.
Have you ever represented a marionette?
I have represented many folks that seem to have their strings pulled, but I don't know if they were truly marionettes.
I see. How about people who just have cold blood? They're just completely cold-blooded, and they block you out of your inheritance just when you would have been a really wealthy puppet.
That's 50% of my practice.
Wow. Can you get Gassman to let me have Saturdays off for a change? He's got me working every Saturday.
I will, but I will go through Marcia and make sure that happens.
Ah, you're smart. Okay, everybody. Welcome to Saturday, September 3rd. I am here with a very good friend and a very good lawyer, a very caring lawyer and a very articulate lawyer, Hamden Baskin III. And we are going to talk about planning your estate to avoid litigation. And the best part is the true stories you won't believe. So let me tell you, first of all, if you have enrolled through CPA Academy, then we will have 4 polling questions. You'll need to answer 3 of them, and then you can leave if you want to. If you have enrolled through our normal website, you will not be getting CPE credit. But we hope you don't care about the CPE credit. But if you're a CPA and you want the CPE credit, you need to get out of our website and come back in through CPA Academy. The handouts today are simply the PowerPoints which you have received. In 3 to 5 hours, you will receive an email. You should forward it to everyone you know. It is a video copy of the presentation and a copy of the PowerPoint deck, which we hope that you will enjoy over and over and over again. If you have a question, go to the upside down pyramid, click it, and then type in your question, and we will answer it if we know the answer, or we'll pretend not to see it if we do not know the answer. Next Saturday, Christy Nicolo is joining me, and we're going to talk about making trusts the beneficiaries of IRAs and pension plans and the other rules for IRA and pension planning. And then the following Saturday, we're going to talk about trust arrangements for children, what planners need to know. So let me mention, we released a Thursday report yesterday. There was a recent article on the Lineberg system. I think about half of our viewers know what the Lineberg system is, where the author said that the Florida Homestead Havico case was being impeded upon by appellate decisions that were saying that you can't put assets at the last minute into Homestead. So I looked at those appellate cases, and the author, quite candidly, is wrong. The appellate cases are saying that if you take ill-gotten gains, you take bad money, money you stole, or money you pulled out of an insolvent company, and you take that money and you pay down your homestead at the last minute, that's not going to be protected from creditors. That's not anything new. That goes back to 1863 and the Florida Constitution. So we had an article on that yesterday. If you want a copy of the article, if you don't get the Thursday report, then just go ahead and put in the RE line of an email, Homestead, and we'll be glad to send you that article. That, I think, was much ado about nothing. In about 5 hours, this webinar will be replayed on YouTube as many times as you like. So that's where you're going to find it. So my friend Hamden Baskin, born and raised in Clearwater, Florida, but nevertheless became successful. A third-generation lawyer, again, successful notwithstanding that he went to Florida State University initially. He eventually went to University of Florida for a master's degree in tax. I didn't realize that you had a master's degree in criminology. That is really, really interesting. Hamden became famous with the Terry Schiavo case, and those of you who saw our webinar with Judge George Greer got to hear about Hamden's colonoscopy. Hamden, anything you would like to say to defend yourself in this background that you have?
Well, absolutely. When I went to the University of Florida, begrudgingly, because Florida State didn't have a tax program and I didn't want to go to NYU, and going to basketball games, I would sit in the student section because I was a student, but I found that I kept getting up and cheering at the wrong time when they were playing the Knowles, and soon learned that that was not a good behavior to do. There's nothing more rabid than a Gator fan, but honestly, I really loved my year in tax school at Florida. It's an experience like no other. Several of my classmates, one went to Boston University, another top LLM program. Colleen Carson, a former partner of mine, went there. Others went to NYU. I got to tell you, I think Florida was hands down. J.J. Freeland, taught us all how to be lawyers, good people, and a lot of tax. So I miss him. I don't know if he's still with us, Alan.
No, he's not. He was a great, great, great professor. Yep. No doubt about it. Thanks to all great professors, especially those of you who are watching. So Hamden, are we going to just dive into some war stories, or do you have some words for the wise before we get started?
Let's go back for a moment on Havco. As Alan may have said, there's very few things in the probate world I haven't litigated. Recently had a case. There was a $500,000 claim against an estate that arose legitimately. It was a claim arising against the decedent in a car accident. And up in New York, they filed a claim down here, but the decedent had moved all of his assets into his home and paid it off up in New York, and then rolled those proceeds into a homestead in Florida. And the judgment creditor attacked. And Alan is exactly right. They tried to argue that it was a fraudulent conveyance, and it was nothing of the kind. The only time you hit that is if you can demonstrate that the proceeds that were rolled in themselves were the product of some kind of fraud. But if it's just your assets, there's no change in the law. So, I agree with you 100% there, and Judge Campbell agreed with us as I expected. But one of the opening things I thought we ought to talk about before we just dive in is, why the heck should we care about what Baskin's talking about? That's what litigators do. If something goes wrong, I'll contact a litigator. Well, there are reasons to really care about what we're going to talk about today if you're involved. Even if you are a referring CPA to an attorney, I have a client, I want to refer him over or her over. What you don't want is end up being a witness in a long, drug-out case, spending a day or two pulling together your files, redacting, getting it over, explaining why this happened, and then sitting for a deposition, all of which you're not going to get paid for because you're a factual witness. You're not an expert, even if you are an expert. You also have a duty, the attorneys have a duty, a fiduciary duty, to take reasonable steps to assure that the estate plan that you're putting together for the decedent, the now decedent, stands up. And so you do need to go through the hoops. You have to understand enough about this stuff to assure that your client, look, I know that you want to favor your oldest son, but we're going to have to take this by the book, and we're going to have to go down this path that we're going to put you through, so that I can make sure that when I get on the witness stand, I can look the judge in the eye and say, I did everything that was appropriate. Now, the other big picture item is that the mantra in our business is that if Alan Gassman puts together a perfect plan and he followed all the rules of engagement to avoid having any possible argument that that he let undue influence slip through. The bottom line is most of these cases say that the undue influence did not occur in the law office. So make sure that that's a true statement. And when you read the Carpenter case, and I think most folks have looked at it, if not, we are going to go down it. That was the Florida Supreme Court's case in 1971 that codified, not codified, but rolled up into a very comprehensive Supreme Court opinion, all of the prior cases telling us all about the world of undue influence and fraud and presumption of undue influence. And some of those indicia of undue influence are directly under the control of the Scrivener lawyer. For example, don't let a substantial beneficiary near your office if you can avoid it. I have sent them home before. Come out to the lobby. Hello, Mr. Gassman. Hello, Susie. Who are you? Well, I've been handling his caregiving for 6 months now. Well, great. You drove him down here? Yes. Now, you wouldn't expect to be a beneficiary in this plan, would you? Oh, yeah. Mr. Gassman says, well, I'm going to leave her everything. Oh, okay. Well, we're not going to do this today. We're going to cancel this appointment. Sir, if you want to call the office yourself, get yourself down here. I don't want Susie anywhere near. I'll talk to you about your plan. Sometimes you just have to say no. And you know, what may be self-evident is that you would not let Susie into the conference room, but my cases involve lawyers that have let Susie be in the conference room. My cases involve Susie calling the front office and saying, I want an appointment for Mr. Gassman. And why are you making this appointment for him? Well, he can't really use the phone that well. Okay. So, I mean, we have all of those things, and it's been going on forever. And so what we want to talk about today is what to look for and what to avoid, and to make sure that you're not going to be one of those lawyers that just gets torn apart in a deposition, and become very disappointed in the way that you actually handled it. So let's take a look at Carpenter. Probably out of order in there, Alan, but it's the 1971 Supreme Court case. And there we go. So this is the one that everybody hears about, in Ray Carpenter. The Supreme Court synthesized the previous decisions of the courts and said, you know what? Undue influence is really hard to prove. It's never something you can really grab with your hands and say, aha, you know, Susie committed undue influence. It's always these amorphous indicia of undue influence. So the court said, you know, we're going to look for a couple of things here. And if they can be established, there's going to be a presumption that the will or deed or gift, and Carpenter's been extended to all those things, was the product of undue influence. And we're going to shift the burden to the proponent of the will to disprove that it was the product of undue influence. So in my business, if I can get to the point of a presumption of undue influence and shift that burden to the person trying to uphold the will, to prove that it was not the product of undue influence, I am really far down the road. And, you know, anytime you walk into the court and you've already won, and the other side has to come forward to overcome it, you're in pretty good shape. So if we kind of cursor down, we get to the indicia of active procurement. And I'm going to roll through a few of them, all of them, but I'll comment on a few of them. And Alan, I think you can probably find it while we're talking. One of them is the presence of the beneficiary at the time the will was executed. So the issues there is most lawyers would not allow the beneficiary to be in the conference room, but it's that pesky lobby that gets in the way. Or if it's executed at home, and that happens, is the beneficiary that's going to get a substantial benefit from the will in the house, in a different room, in the kitchen. So always make sure if you're making a house call that that beneficiary is not within earshot. And the best thing to do is send her or he out to the garage or into the car and tell them to take a ride. And these home cases also usually involve finding witnesses. And inevitably, it's that beneficiary that went over to her girlfriend or his boyfriend or whatever, neighbors, and go round up the witnesses. So if you're going to make a house call, even though it's expensive and you may not be able to recover all the expense, take staff with you. You don't want to go out there and have the neighbors be the witnesses. They move, they don't know what to look for. It's nice to put your paralegal on the witness stand and say, how many times have you been a witness to a will? 100. I've worked for Mr. Gassman for 18 years. And a lot of those have been elderly folks. Yes. Did you speak with the person? Oh yeah, we had small talk. Any concern in your mind that this person didn't have sufficient capacity to execute a will? Oh no, he's very sharp. So you know, watch for that one. So presence, the witness, the beneficiary being present on occasions when the testator talked about making a will. And that's a tough one to control. That never happened in the law firm. But what you can do is ask your client, and if you see some of that, then make sure you prepare a memo for the file saying that you had discussed all of this, that you reminded them that you're cutting out 2 of your children. There's probably going to be some fussing, and let me put some good reasons in my memo as to why you wanted to do this. And many of the times it's going to be because the other children aren't around, haven't called, haven't sent Christmas cards, and are just waiting around for the parent to die. That's a pretty common fact pattern. I unfortunately see that quite a bit. So get something in the file, and your file is going to be subpoenaed. And so having some of that in there is a good idea. Now, oftentimes, Alan, I'll get asked, well, should I have it videotaped? And I think that's a very bad idea for the most part. You're going to create a record. And if the testator says, well, I'm in New York City, that's on tape. You're not going to be able to get rid of it. Even if you stop the film and say, hey, you're in Clearwater, and then they go, oh, I'm in Clearwater, it's not going to work. I've had many of those cases. And even when it comes out okay, the other side will say, well, you videotaped it because you were expecting a problem, because you saw there was going to be litigation. And it's tough to get around it. So if you can avoid videotaping, that's good. Sometimes you haven't got a choice. Recommending the attorney is another one. If you can find out how you were referred in, and if you were referred in by the substantial beneficiary, put in your note that you reminded the client that he or she could go anywhere. And, you didn't get my name, your son referred you in, but here's my credentials, just go through that. Giving instructions is something you have control over. The beneficiary giving instructions to the attorney happens all the time. Many times it's a grandchild that calls in and says, my granddad wants to change his will to leave it to me. So you're not accepting those. And a lot of times when that happens, I'll make sure that the person is told your granddad will have to call in and you have to start all over. You want to walk away from cases that you know you're going to end up being on a witness stand twice, once for the deposition and once for the trial. Safekeeping of the will, that's another one. So when the substantial beneficiary is in the lobby, don't hand the will to the beneficiary. I had that case a couple of years ago, and unfortunately, the lawyer admitted that she handed the will to the beneficiary. And so the other side said, aha, the beneficiary took possession and custody of the will. Well, that's not what happened. The beneficiary gave it back, but you know, you've kind of lost the moment. So I don't know if we need to do the polling question, Alan.
Alan, it looks like you muted yourself. Go ahead and check your jobber speaker for me.
Yeah, there you go.
All
right,
good.
so the question, which is true about Hamden? Number 1, born in Clearwater, Florida. 2, master's degree in criminology. 3, post-law master's degree in taxation. 4, all of the above. Sorry, I was muted and said it all twice. Please put in D, all of the above, if you're with CPA Academy, and then we'll go to the next slide.
All good.
All good. All right, Hamden, where were we? Sorry.
All right, so we've been kind of through and they're not exclusive. And depending on the case, any one of those will be enough to justify a finding of active procurement. But there's 2 other elements. One, primarily the beneficiary needs to be a substantial beneficiary that benefits by the undue influence. Although there is case law that if the beneficiary that benefits hooks up with a third party who they push the undue influence through a third party, the son's girlfriend is a typical pattern, then there still could be a finding that that was a undue influence case, even though the actual undue influence didn't happen by the beneficiary. The second one is what we're going to spend some time on today, the confidential relationship. Carpenter says that in order to get the presumption of active procurement and the presumption of undue influence, you have to have a confidential relationship with the decedent. And that takes the form of powers of attorney, helping pay bills. Sometimes it's amorphous, and the court says it is. It's got to be looked at individually in each case. Confidential relationship can be many things at different times. But if the trial court finds that you have a confidential relationship, then if the court then finds that you are a substantial beneficiary and one or more of the indicia of active procurement are there, that presumption of undue influence is going to attach to the will, and you're going to be spending a lot of time in court that you don't want to do. So, Carpenter floated along, and not everybody was completely happy with it because it had one more element, and that said, well, let's say the trial court finds active procurement, shifts the burden to the other side to prove the will's not the product of undue influence. Carpenter says, but if you come forward and say, here's a reasonable explanation for why I was involved in helping this person do their will, the presumption vanished. And now the burden shifted back to the other side to prove the will was the product of undue influence. So that was not good. And so the Florida legislature modified that rule. And I didn't put that into your materials, but you'll see it in the Florida Probate Code under 733.107. And in that statute, they simply say, and that was effective in 2014, in any transaction or event in which the presumption of undue influence applies, the presumption implements public policy against abuse of fiduciary or confidential relationships, and therefore the presumption of burden of proof under 90.301 shall apply. Well, what that means is that even if you come forward with a reasonable explanation for why you drove the decedent to Alan's office, or why you took custody of the will, or why you were helping pay bills, that wasn't enough. The presumption of undue influence attached and would go all the way through trial, and you retain the burden to disprove that the will was the product of undue influence. So to that extent, Carpenter was overruled in 2014, but only to that amount. So as time goes on, litigators started looking again at this issue of confidential relationship and said, you know, there were some cases that talked about family settings. And we know that a husband-wife, by definition, is a confidential relationship. And so the husband-wife arrangement has never been subject to the presumption of undue influence. Every marriage has undue influence. That's what spouses do with each other. So it's no different here. If your decedent's wife said, you know, I know my daughter's not your kid, but you better leave half of it to my daughter or I'm divorcing you, nothing you can do about it. That is not going to get a presumption of undue influence. So they began to look again at some older cases and some that are maybe not as old. And they looked at the Kester versus Rococo case in 2013. There was also the Carter case, 3rd District, back in 1988. Both of those are in your materials. So what we have then is, wait a minute. Are you telling me that if the parent has 3 children, 2 of them are out of state, and the child that's here takes care of the parent as appropriate? That's what family's supposed to do. And so we're looking at this issue and saying, well, oldest son, who ended up being a substantial beneficiary in the Carter case, helped mom fix her will. And every single element that we talked about in the Carpenter case was literally present in the Carter case. And this is called the dutiful son case. And for some reason, that case kind of disappeared from sight. For the most part, it seemed to be an outlier, and being a 1988 case, but it did seem to go against Carpenter because there was nothing in Carpenter that said there should be an exclusion except for a spouse. But when you look at Carter, you'll see that the deceased father had expressed a desire to fix the estate plan. He died before it could happen. Mom is getting up there. and she says, he tells her actually, Mom, Dad wanted to fix this. And here's what he wanted to do. He wanted to return the estate plan to equal beneficiaries. And so she said, yes, make that happen. So here he's involved with the decision. He knows what it's going to be. She then tells him, make it so, number one. So so he finds an attorney in Jacksonville and gets this thing done. And lo and behold, when Mom passes, the other kid's not so happy. And there you go. Returning from Jacksonville, he had his lawyer. I mean, come on, Carpenter, where are you? We'll draw up the will, following his mother's directions. He then returned it to her to Miami, where they went over it. He left it at her house. And then some days later, he took his mother to the office of an attorney near home, and she signed it. So we couldn't have a better tracing of the Carpenter act of procurement than we have here. So, you know, what would the court do? And the court made a very wise decision. You know, family takes care of family. And if every case involving a child is going to immediately trigger the Carpenter, then we're going to have problems. And I'm going to give you a quote in a minute, but here where Alan has flashed up, once the familial situation has been brought into proper focus, it is clear that the actions of James and Carl in executing the will were perfunctory physical activities rather than active procurement. They were doing what their mother wanted. Their acts were of dutiful sons who helped their mother draw up her will and execute it. She was aging and needed helpful information and even advice. Her sons were shown to maintain constant contact with their mother. James handled her financial affairs. Carl made repairs on the home. Both saw that her physical needs were met. It's either in this case or in the daughter case that we'll talk about, but I really like where the court said, if the law has reached a point to where children cannot assist their aging parents without essentially risking an immediate presumption of undue influence, we have finally destroyed the family unit. And you think about it, most of our cases do involve family settings. I love the few cases we get that would be the caregiver comes in at the last minute and gives a great shower, gives a great bath, all those things that I think lead to someone changing their will to a complete stranger. And in those, there usually is a pretty good load of diminished capacity. And the other overarching, I guess, consideration is that we're talking about decedents who either lack capacity or were of diminished capacity, such that they were unable to overcome the undue influence of the undue influencer. But this carve out for the dutiful son has now become quite a topic. And so we're waiting for more decision making in that area. But I can tell you, and I didn't put it in the materials, but if you have more interest on some good reading, Alexander Douglas, who's a friend of mine, a great lawyer, did write an article. It's in the May/June volume of 2021 in the Real Property Probate and Trust Law booklet. And he summarizes this well. I think we have another quick poll.
Yeah. And then Hamden, after the polling question, I want to switch gears because most of our attendees are not in Florida and most of our attendees are not lawyers. So I want to start talking practically about how you avoid this happening in your family.
Okay.
Okay, so this polling question is, do you want to subscribe to the Gassman, Crotty, Denicolo Thursday report? I recommend against it. It's not a very good report, but the choices are A, yes, B, I already do, leave me alone, or C, I would rather have a spinal tap. If you do select A, we will install you into the Thursday report. It's free and often comes out on Thursdays. Brittany, is the audience awake? Okay, all good. All right, so Hamden, I'm gonna go back to the very first slide here. Planning your estate to avoid litigation with true stories you won't believe. Okay, so far, I believe your stories. And I think in all 50 states, if somebody brings this person into the lawyer's office and says, oh, this is my friend John, we just met last week, he wants to leave everything to me, can you please draft up a will? Well, there's going to be a presumption of undue influence. And what does the lawyer do? Well, if the lawyer really wants to make $275 that day, the lawyer goes ahead and does the will, realizing that the lawyer, you should put in your fee agreement that you'll be paid for all your time testifying, because you will spend a lot of time testifying. And then there's the tougher call. The tougher call that Hamden and I see a lot is, well, mom and dad have 4 children, and one of them is somewhat dysfunctional. And mom dies, and dad needs help. And the dysfunctional child needs a place to live. So suddenly the dysfunctional child is living with dad. And unfortunately, before mom died, we weren't smart enough to put a trust in place. For example, I met with a client by video Thursday, and they explained that they have 4 children and one is not balanced and doesn't always have a place to live. And I said, well, guess what? If one of you guys die, I know where she's moving, and then I know what's next. So we changed their documents to set up a trust that becomes irrevocable on the first death. So then if dad dies, mom's going to be co-trustee with her choice of any trust company or any reputable board certified lawyer or any 2 of their 3 sons, but the daughter cannot be a co-trustee and can't inherit more than her share. So Hamden, kind of changing the subject to that, what are your thoughts for an audience that really doesn't want to see half of their estate go to litigation and the other half of their estate go to a pool boy or a Hooters girl or a caretaker?
Wow. So what you're talking about is a safety latch provision that you've talked about before, so that before a change could be made, certain things have to be in place and done. So that's excellent. And Alan and I have had those cases litigated before, and the safety latch has been successful in every case. I recommend it. And it does point up that there is a concern when you feel you want to put a safety latch in, that there could be a challenge. There could be a challenge because, well, dad's not quite as sharp as he was, or mom, but we've also coupled the change to a trust or even the execution of one to say, would you please see your doctor and get kind of a letter indicating that the doctor has no concern with your current capacity to execute a will. So I like those, but inserting the safety latch, Alan, I mean, I think it works. We've had them challenged, and so far there's never been a successful challenge.
Right. So the first thing I talked about was the husband and wife, the married couple, set up a joint trust, and when one of them dies, it becomes irrevocable. So if the surviving spouse,
there's somebody with a lawnmower out there that I need to turn up my volume or something for a moment. There, it's better. Okay.
Okay. So the first thing, what Hamden was referring to, the safety latch, is also used to be called a Ulysses Clause, I think. And what it says is my trust is revocable and I can amend it anytime I want, but only if it's clear that I'm not under undue influence, as evidenced by signatures from any 3 of the following 6 people, or a clearance letter from 2 neurologists who have both examined me and say that I'm not under undue influence. Unless I can get those signatures, I can't take more than $10,000 a month out of my trust, and I can't change my trust. And that's the safety lapse provision. And then the housekeeper calls and says, I want to bring Mrs. Jones in to change her trust. She wants to leave me $300,000. I say, that's fine. We need signatures from one of the 3 out of these 6 people or 2 neurologists. And then the housekeeper says, well, never mind. So that's the safety latch clause. The other clause I was talking about is a married couple sets up a joint revocable trust, which simply becomes irrevocable on the first death, and the surviving spouse can't change it. The surviving spouse can live from it, but can't change it. And therefore, when the surviving spouse remarries, the new spouse is not going to inherit anything that is in that joint trust. So those are a couple of ideas. Now, I've used the video the opposite way, and that is the client wanted to be very unwise and was very forgetful. And I disagreed with what he wanted to do, but he was adamant that he wanted to do it. So I said, that's all right. Could I video this? And he said, yes. And then I said, oh, I have a new law student who's working for me. Would you mind having lunch with her while I prepare the document? So for 45 minutes, this law student had a videotaped conversation with my client, and he repeated himself over and over again. He kept asking her what his address was. He kept asking her who his girlfriend's name was. And later on, when we showed that tape to people, they said, oops, never mind. We're not going to try to defend this. The other nice thing about the videos, though, if you do the video and you interview the client about their life, then the family may really appreciate it later when the client dies, because the family never knew anything about their life. No one ever listened to grandpa. So having grandpa talk about his life for an hour and a half, even though he repeats himself every 15 minutes and doesn't realize what he's been saying, you're verifying a couple things. One, that he didn't really know what was going on. And 2, at least the family has a history that they can watch during or after the funeral, or at least a transcript that they can read.
Yeah.
But Hamden, what are some other good ideas or stories that would be helpful? But first, let me do another another polling question. All right, quick polling question. So we got 3 out of 4 out of the way. Would you like a PDF copy of our book, 8 Steps to a Proper Estate Plan? A yes, B no. Otherwise, check your emails, walk your dog. We'll be back in 10 or 15 seconds as soon as Brittany gives us the all clear. Brittany, are you there to give us the all clear?
You're all good.
Okay, but it was supposed to be all clear. All right, so Hamden, what are your thoughts?
Absolutely. One quick point, there is an old Florida Supreme Court case that I think it's in the 30s. And this attorney allowed someone that was clearly demented and was leaving his estate to someone that was there. There was alcohol involved. It was awful fact pattern. And so the Florida Supreme Court said, look, it's not the duty of the lawyer to actually play judge and jury. The idea is to get what your client wants done, and then if there's going to be a challenge, that's up to a judge. So I think we do have a duty to go forward where we can, but we want to take those steps that Alan's mentioning to make sure that what we do is going to work. I have a question that I generally ask when I give seminars, and I ask, how many of you practitioners actually send a draft copy of the estate plan to the proposed client or maker before they come in to sign? And it's about 50%. And I think that's a bad idea. And I asked why. Well, I'm afraid they'll just take my documents, even if I watermark them. They won't come in, they'll get them retyped, they'll do all these things, and they'll beat me out of a fee. And I say, well, there's two answers to that. One, get your fee up front then. Or number two, wouldn't you rather give up a part of a fee than sit in a deposition for a day, sit in trial, have to deal with producing your file? So getting that draft out and putting in your cover letter a short synopsis of what it does. And dear Mr. Gassman, you've chosen to cut out your oldest. That is your right to do so. I've reminded you that you may change your will anytime you want, or your trust. You can put them back in. And then if you're satisfied with this, make the appointment and come in. Or if not, please phone in and we'll make any changes. And then they come in and they sign. And then I do a closing letter immediately. Dear Mr. Gassman, it was nice to see you Friday. Again, your will cut out your oldest. We talked about it. Here's why you thought that was something that you really felt you wanted to do. And I'm reminding you that you can call up anytime and tell me that you want to change again, and you've had a change of thought and you want to put the person back in. I recommend it, and I don't know with the audience how many of them feel comfortable sending drafts, but having somebody come in to sign something for the first time they've seen it, when they're already, and we're talking about older folks typically, we always get hit with, Judge, they couldn't possibly understand this 32-page trust. They saw it for the first time, and you know, there's arguments against that, but I don't like that. I like to be able, when I get that phone call that says, Hamden, I'm looking at a will that you drew and I'm going to challenge it. I said, well, before you do, you ought to know the following. In the rules regarding confidentiality in the code of conduct do permit the lawyer to provide enough information even after the death of the client if it may avoid family litigation or litigation. So I have no problem with saying, just so you know, this one was by the book. It's what he wanted. He had drafts, just the whole thing. So many times that will end it right there. Alan also mentioned the video, and I like what he was talking about, and it can be very devastating in upholding a will. But just remember, if there's questions about how it's going to look, and you might question, but then Alan and I have had other cases and even current cases that involve changes to an estate plan, but the attorney, and it wasn't Alan or I, but the attorney had the maker see his neurologist every time a change was made. And there was a letter saying, I examined this person this morning and he is capable of understanding a change to his trust. And that, that goes a long way, believe me, in trying to uphold these things. So that's another real possibility. Now, I've had a recent case where, unfortunately, the doctor said, I don't think I can give that opinion. And now the other side has found out about that. And so now that's kind of like the bad video, because this stuff is all record evidence. So you just have to be careful. You have to use your judgment. But those are things that ought to be done. Alan, and definitely avoiding those elements of carpenter. And by the way, I understand a lot of folks are out of state. I'm involved with a lot of cases, and almost every state has similar laws. In fact, carpenter even cites some out of state things. So I think a lot of this is generally applicable. But looking at the indicia in carpenter that you can control. Don't take your instructions from the wrong person. Don't let the beneficiary be in the room. I mean, those really obvious things you should take as the gospel, and that should go a long way in knocking the case out right away. The other thing I would watch for, always careful, is with the deathbed, hospital bed changes. I'm kind of like Alan in that one. I feel like that's one you ought to let go. Nothing good's going to happen with that. So try to avoid that. Now, if you are the longtime attorney and have sufficient time with the client that you're prepared to say, Judge, I've known this client for 15 years. Yes, he was in the hospital dying, but I ran everybody out of the hospital room, and I'm very comfortable that the client I knew was still competent. But other than that, if it's a fresh call, do not get involved. So you've thrown up another item which has to do with the trust protector. I like the trust protector. You have some comments on that, Alan?
Yeah, in fact, Hamden, about a week ago, you and I had a discussion about a trust that had some issues in it. And I'm representing one of the beneficiaries, and things are not going as the decedent wanted them to go. So after you and I spoke, I called the trust protector and I said, hey, you know, the son's not doing what we thought he was supposed to do. My client's disappointed. Would you mind amending the trust to give us more rights? And the trust protector said, no problem. Send me what you want it to say. So I drafted it up. I sent him what I wanted it to say. He changed a few things and then he signed it. And now things are, you know, back to what we think the decedent wanted. So we have two kinds of trust protector provisions in our documents. One says that Uncle Charlie can change just about anything with the permission of the surviving spouse. And then the second one says our law firm, as having drafted the document, can correct errors with the consent of any beneficiary. So if it's a grammatical error or a technical error or an ambiguity or an inconsistency, I can just go in there and correct it, get one of the beneficiaries to sign off, and not be held hostage by somebody who tries to take advantage of every little nit and pick.
Yeah.
Because that's what happens. You get a professional discontent. That's what they do for a living. That's their hobby. They go through every page of your document. They find or should have been and why is that comma there? And they're going to hold you up until your dying day. No, I'll just fix that and go to the next thing.
Yeah, the trick on the trust protector, and I've litigated many of them, and the case that you cite is really interesting. I believe it was went up on appeal several times, but it has different aspects of it, but it's worth a read. But the trick in your drafting is to go with the comprehensive trust protector provisions that Alan has mentioned. One of the questions, of course, is does the trust protector have an affirmative duty to look at it and make corrections, or does he or she wait for a question to be presented? Because the trust protector can have liability if they're supposed to, for example, change the trust to meet new trust code items. But that is one of the strongest things that we can have. If you read that case, the court deferred to the trust protector and upheld the trust protector. So that's an excellent recommendation, Alan. And I don't see it in very many of my instruments that come through for litigation. And it should be in all of them that would be in any way a high wealth case.
Yeah. Okay, we're going to go to the last polling question. The last polling question is, in the future, would you like to hear more about one, how to make your office more effective and enjoyable, 2, B, the mathematics of estate planning, part 3, C, planning with code section 199A, 678 trusts and complex trusts, or D, spousal limited access trusts from A to Z. So this one, just let us know. That gives us an idea of what we should talk about in the future. By the way, Hamden, Michael, when you said neurologist the first time, you accidentally said urologist.
Oh,
So I was kind of thinking, what was that man thinking with if he had to go to a urologist as opposed to his neurologist?
many people feel that way. That's for
Yes,
sure.
they do. Yes, they do.
All clear.
All right. So
Okay.
there is one other thing I did want to mention briefly, and we can go back to Alan's thoughts, but there is a growing body of law, and I suspect this is true in every red and blue state out there, irrespective. The courts are expanding the liability of the attorneys and fiduciaries to the point that I think, we've always known that a beneficiary could come in and sue if you screwed something up that shouldn't have been screwed up. You were supposed to get this plan done that would stand up, and because you let me in the room, you let me give you the instructions or any of those kinds of things, this will got set aside. And so under the older law that's now expanding, you could be liable for malpractice to a beneficiary. The cases are really moving towards holding lawyers liable and fiduciaries liable. So that's another reason why we should care about what we're talking about today and make sure all these things are done, because it looks like to me there's a new burgeoning area of lawyers that sue lawyers for, that's kind of like, okay, malpractice in litigation and all that's one thing, but this new little boutique area is going after lawyers for failure to do what they were asked to do in an estate plan. There's a couple of new cases, fairly recent cases. So the kinds of things that are out there already would be not really addressing who should be an agent under a power of attorney. Find out who your client is appointing. Well, it's my son. Well, does he have a record? What do you mean, other than the robbery he did 5 years ago, he'll be out of prison soon? I mean, look, that's a silly example, but find out more and document, if you need to, that you recommended against the son who had just gotten out of prison to be a POA, a power, a fiduciary in any of that, because that's a fact pattern in one of the cases. So just go through the numbers and don't be embarrassed to ask, has your son ever had a problem? I mean, I'm only asking you because I want to make sure what we do is the right thing. And people get very defensive when you ask about their family members, but I would do that. So just a quick thought there.
Yeah, I mean, one of the things I tell new doctors when I give my talk for new doctors, and also new lawyers in any profession or any business person, when you interact with somebody, just spend 45 seconds thinking what could go wrong here, and get something in writing to try to prevent it from going wrong, and to try to let the client know it could go wrong. So one of the things that I'm always saying is, if something happens to you, you have an addictive child or an off-balance child, they're going to want to move in and take over. So we need to protect you against that. And then the other thing, and I have this slide up, and I know our time's about up, but if the client is going to choose a trustee or a personal representative who you don't know and you don't know if they're good or not, just suggest, well, could that person serve as co-trustee with their choice of a reputable lawyer, CPA, or trust company? Because somebody who might really be a terrible trustee actually won't be so bad if they have to have a co-trustee. And then if the client says no, do you still keep a provision in your document, which we often use this provision that just says, well, Uncle Joe will be the trustee, but the beneficiaries by majority vote can require him to add a trust company or a reputable law firm selected by him to be an additional co-trustee.
Yeah.
So that, it's less likely that this trustee who the client has naively selected will be, cause as much damage as they might otherwise cause. Hamden, the last thing I wanted to talk about, and I know we're over our time here, but I wanted to talk about arbitration.
Yeah.
Because you're one of the few litigation lawyers who is not offended when I mention arbitration. And I know you can't require in a trust document or a will that every aspect of the situation be arbitrated. Judges stay in charge of things. But one of the things I like about arbitration, besides the fact that it stays public, and in court it's not at all public, is that litigators just don't like arbitration, and they're less likely to go to bat and try to go to trial if they have to go to arbitration versus going to court. And I'm just interested in your thoughts on that.
Yeah, that's true. I believe the case law would indicate that an arbitrator, however, cannot determine whether a will is valid, but there are many aspects that should be arbitrated or could be arbitrated or mediated. But the accountings are one. There's just a whole lot of things that could go to arbitration. Lawyers, litigators are not enamored with arbitration because it's a little loosey-goosey in terms of the rules. You go in and it's pretty much up to the arbitrator, and arbitrator is a derivative arbitrary. So that's a term of art in the literature regarding arbitration, and by definition, the whole proceeding can be arbitrary. But the arbiter, he or she decides what comes in, what they want to hear. You're not going to say, well, objection, that's hearsay. None of that happens. Sometimes the entire story comes out a little better if we're not kind of blocked by the rules of evidence, and the arbitrator can really get to the meat and potatoes. I like your requirement that it be a board certified attorney with 20 years practicing more than 100 miles from the residence, because that is one of the things that comes up. Somebody wants to attack a will from a local attorney. The court knows this attorney does everything right. It's going to be a little tougher. So getting somebody that doesn't know the attorneys is I think, one way to keep it very neutral. It can be a little more, at least up front expensive, but if you get it done, it's cheaper. Now we are seeing a lot more mediation than we ever had before. I mean, almost every one of these will contests goes there, and that one has worked out pretty well. But I think we're going to see more alternate resolution, including arbitration, because our courts are just clogged. Our probate judges have over 3,000 or 4,000 cases each, and it's just a crapshoot, So arbitration is, I think, and the other one is going to be collaborative law, is going to find its way into what I do for a living. And the family law attorneys have been using it, Kai Koch and others, as a great way to keep things private, to let everything come out and be heard. But, if they collaborate and are able to get it resolved, it's over. If they don't, neither one of the collaboration attorneys can have anything to do with the litigation. So that really puts pressure on the collaboration lawyers to get it done because, you know, they'd rather stay in and get it done because they know they can't be a litigator in the case if it fails. So all those things, Alan, we're rolling up as alternate dispute resolution, the arbitration being the most forceful, then probably collaborative, and which is now coming in a little bit, and then mediation is generally required before we can get to trial.
Yeah, I'm gonna mention collaboration again because of the layman on this video. It's been very, very effective in Florida. Both divorce lawyers, the lawyer for each spouse, both agree that if we cannot settle this out of court, we will quit and new lawyers will have to be hired. And then at the same time, usually a common financial advisor is chosen, normally a CPA who has a lot of forensic experience, and a psychologist is chosen. And the 6 people sit down, the 2 spouses, the psychologist, the forensic expert, and the 2 lawyers. And the 4 professionals say, we get paid by the hour or by the job, but if we're not successful, we all lose our jobs, and this goes to court with completely new lawyers. And it works. It works very, very well. So I really like the idea of collaborative negotiation of trusts and estates, that the lawyers we bring to the table for each party would have to quit if it goes to arbitration or litigation. That's a fantastic idea.
Yeah, absolutely.
We'll be doing that. Okay, well, I know that we have just scratched a very interesting iceberg today of all of the aspects that go into estate planning and trust planning and trying to avoid litigation. So, Hamden, it was fantastic having you. I'd like to do a part 2 one afternoon to cover some of the strategies we didn't talk to, maybe tell a couple of other stories if you're interested.
Enjoyed it. Would be happy to.
Yeah, I think we did a pretty good job of answering all the questions that came up. If you have any further questions, you can email them to hbaskin@baskinesel.com that you see there, or agassman@gassmanpa.com. As always, if you'll send Hamden the hard questions and send me the easy questions, we'll make sure everything gets answered. Thank you so much for attending this presentation, and have a fantastic rest of a great Labor Day weekend.
Thanks, Alan.